Today, we're going to discuss how estates are administered in New York and whether wills still make sense in 2022. Hi there, my name is Stephen Turman. I have more than 20 years of experience as a trial attorney and appellate advocate in New York. I'm the founder of Turman Legal Solutions, which is a boutique law firm located on Long Island that specializes in trust and estates planning, litigation, and administration. We'll start off with our first question. What is a probate proceeding? When you die and leave behind a last will and testament, the estate administration process is divided into three primary steps. Probate is the first of these three steps. In New York, there is a special court called the Surrogates Court that is responsible for administering estates. As part of the administration process, the Surrogates Court is responsible for determining if a will is valid and enforceable. The testator, who is the person who creates and signs the will name one or more people to serve as an executor of the estate. The executor serves as a fiduciary to the testator with the responsibility of probating the will and administering the estate in accordance with the testator's wishes. To start a probate proceeding, the executor causes a probate petition to be filed with the Surrogates Court along with the will and the death certificate. In the probate petition, the executor will provide the court with certain information, including the approximate value of the assets in the probate estate, the names and addresses of all beneficiaries named in the will, and the names and addresses of all heirs at law. Heirs at law are the people that would inherit if there was no will. Heirs at law include the decedent's surviving spouse, children, parents, grandchildren, siblings, aunts, uncles, nieces, nephews, and cousins. After the petition is submitted, the clerk for the Surrogates Court will review the documents, confirm that they are complete and conform to the court's rules. If they are complete and conform to the rules, the clerk will issue a citation that is intended to put all interested parties on notice of the probate proceeding. The citation, if you've ever been involved in a lawsuit, sorry if you have, a citation is the equivalent to a summons issued in a civil lawsuit. The citation will also include a return date for any interested parties to object to the probate of the will. If there are no objections to probate and the will does not have any obvious defects on its face, the surrogate will likely admit the will to probate. However, if an interested party objects to probate, litigation begins to determine if the will is valid and enforceable. When this occurs, the opposing sides are entitled to discovery and a trial before the Surrogates Court to determine the will's validity. I'll dedicate another video to discussing will contests and objections to probate since it's a little bit much to go over that in this video. For today's discussion, we can assume the will is valid and admitted to probate. What happens next? Once a will is admitted to probate, the Surrogates Court will issue testamentary letters to the executor. Testamentary letters are legal documents that give the executor the power and authority to administer the estate. To fulfill the executor's fiduciary obligations, the executor must locate and take possession of all estate assets, pay all taxes owed by the decedent, preserve the value of the estate assets, liquidate the estate assets, pay all creditors, and finally make distributions in accordance with the terms of the will. The amount of work involved will vary considerably depending on the complexity of the estate and the types of assets involved. In attempting to fulfill these obligations, executors face many potential pitfalls. They need to be particularly careful when making decisions concerning the management of estate assets because executors can be held personally liable for any actions taken that cause the assets to lose value. For example, if an estate owns real property and the executor fails to pay the mortgage and real estate taxes on the property, penalties and interest will accrue that will diminish the value of that asset. In fact, it can even result in foreclosure of the asset. In this case, the executor may need to use estate assets to pay off the penalties and interest, but ultimately the court will hold that executor liable for the damages caused, and the executor is going to have to pay for those damages out of his own or her own personal pockets along with interest. Not fun. After the executor liquidates all estate assets, he or she must pay off all the estate's creditors After those expenses are paid, distributions are made to the beneficiaries under the will. At the time distributions are made, the executor will generally request a release from beneficiaries from liability associated with the administration of the estate. However, beneficiaries are not required to provide a release to the executor. So, all assets are liquidated and distributions are made. What does the executor do? Well, the executor should hold back a reserve to cover potential liabilities and expenses that maybe were overlooked or may come up as part of the third stage of this process, which is closing out the estate. For example, when closing out the estate, it's possible, even likely, that the estate may have some tax liabilities for any income earned during the administration. Some of these administrations could go on for a few years, so it could be a decent amount of tax liability that accrues. There may also be fees associated with any accounting and other expenses that are likely to come up while closing out the estate. This could be a relatively simple process of the executor preparing an informal accounting and getting releases from all beneficiaries. If the executor is not released by all parties, the executor will need to file a formal accounting with the court and petition the court to accept the voluntary accounting and enter a decree releasing the executor from liability. Once again, the clerk of the court will issue a citation that will have to be served on all beneficiaries of the estate, giving them notice of the accounting and a deadline to object or request discovery. If none of the beneficiaries object or request discovery, it will be a relatively straightforward process of getting a decree releasing the executor of liability and closing out the estate. However, if there are objections or requests for discovery, it could be a long, litigious, and expensive process to close the estate. So, how long does it take to administer an estate when there's a will? There is an uncontested estate administration for a relatively small estate without complicated assets. It can take anywhere from 12 to 36 months to complete the administration process. Right now, it may take a little bit longer, maybe a lot longer, because many surrogates courts are backed up from cases that were dormant during COVID-19 lockdown, so the courts are still trying to work through their dockets. Even in uncontested proceedings that have more complicated estates or more complicated assets that are not as easily liquidated, the administration process can take considerably longer. If the administration involves objections to probate, motions to remove the executor, or contested accounting, these estates can take years to fully administer. So, estate planning based on a traditional last will and testament may still have a place for smaller estates, but in most cases, use of the traditional will and probate is probably best avoided in New York. Living trusts offer a superior option over a will as the cornerstone of a comprehensive estate plan. Even with a living trust, there may still be some assets that may need to go through probate, but if planned correctly, the process shouldn't be litigious, nor will it tie up a bulk of the decedent's assets while you're waiting for the court to work its wonders. It may cost a little bit more, sometimes considerably more, to be honest, to create an estate plan using a living trust as a foundation, but it will certainly save your loved ones considerable amounts of money, time, and tears in the long run. If you found this video helpful, please press like and subscribe below. Please leave any questions or comments you may have in the comments section. If you're in New York and you need help administering an estate, or you're a beneficiary that is concerned that a estate is being mismanaged, I'd be happy to speak to you. I'll leave my link to my law firm in the description below. Thanks so much for watching and have a great day.